When special statutes remain silent about the jurisdiction of a court for filing a suit, should we take the help of the provisions of CPC? Because CPC is a governing law. Let me discuss this issue in this video. Before I go ahead, as far as this issue is concerned, I would like to say something about the provisions of IP laws as far as jurisdiction is concerned. Section 134 is related to the jurisdiction of the court in Trademarks Act, 62 in Copyright Act, 104 in Patent, and 22 in Designs Act. The jurisdiction of the district court, it is everywhere mentioned that once there is violation of infringement of any IP laws, that is infringement of trademark, copyright, patent, design, then district court has jurisdiction to entertain and adjudicate the suits. After that, I would like to discuss the provisions of groundless threat. The provisions of groundless threat as far as section 142 of the Trademarks Act 99 is concerned, as far as 60 of copyright, 106 of patent, and 23 of the Designs Act are concerned. These are the sections related to the groundless threats. The question is arisen, what is groundless threat? In a very simple term or language, by giving one example, let me say this. Suppose Mr. A is sending a legal notice or is circulating something or advertising something which is infringement in his own opinion, or which is infringed by Mr. B in his own opinion, and in the opinion of Mr. B, to whom that legal notice is sent by Mr. A, that is noticee, he is not violating any IP rights. Under such circumstances, whether Mr. B, who is noticee, is entitled to take any action against Mr. A, these provisions answers in affirmative. These provisions say yes, Mr. B is entitled to take legal action against Mr. A, and this legal action is called, or the suit is called, for groundless threat, because Mr. A is threatening Mr. B by circulating or by advertising or otherwise. The term otherwise includes sending a legal notice. Now, as far as the term otherwise is concerned, it is given in Trademarks Act, it is given in Copyright Act. However, this term is replaced by certain words in Patent Act. It is said that by communication, oral or in writing, these are the words which are replaced in place of otherwise in the Patent Act. And section 23 of the Designs Act depends upon section 106 of the Patent Act. So these are the provisions for groundless threat. Now, the issue of cause of action or the jurisdiction of a court to institute a suit for groundless threat is the topic of today's video. All these sections earlier which have been mentioned earlier, that is section 134, 60, 22 and 104, these are the sections which mentions infringement of IP rights. These sections does not say anything in respect of groundless threat. And one important aspect, is this section says that the cause of action is arisen where the plaintiff is residing or is carrying on business or is working for personal gain. However, there is some difference as far as section 20 of CPC is concerned. Section 20 of CPC says that where the defendant is residing or is carrying on business or is working for personal gain, or where the cause of action is arisen. So the special statute says about infringement action. The special statutes remain silent about the action to be taken as a groundless threat. Now, what would be the situation then? Mr. A is sender of the legal notice. Mr. B is a noticee who is not at all infringing the rights of Mr. A, and that is why, being aggrieved, Mr. B would like to take action against Mr. A. Under such circumstances, Mr. B, who is a noticee, is or would be proposed plaintiff and Mr. A is proposed defendant. Mr. A is sending a legal notice to Mr. B from Ahmedabad. Mr. A is situated in Ahmedabad, Mr. B is situated in Mumbai. So the cause of action, I am talking about the cause of action being arisen. Where does the cause of action arise? Because special statute remains silent in respect of the suit for instituting of groundless threat. So should we take the help of section 20 of CPC? The answer is yes, we should. Section 20 says two options. One, where the defendant is residing or is carrying on business or is working for personal gain. Second, where the cause of action is arisen. Now here Mr. A would be defendant who is residing in Ahmedabad and who has sent this notice to that Mr. B who is residing in Mumbai, and Mr. B is proposed plaintiff. So in the suit for groundless threat, Mr. B is plaintiff and Mr. A is defendant. So as per section 20 of CPC, the suit for groundless threat is required to be filed in Ahmedabad and not in Mumbai. Second, the suit is required to be filed where the cause of action is arisen. Here Mr. A is sending a legal notice to Mr. B who is residing in Mumbai. That is why the cause of action is arisen in Mumbai. But the question is, or the problem is, Mr. A is sending a legal notice at the postal address of Mr. B's office or resident. However, and that is why the cause of action is arisen in Mumbai. However, Mr. A does not send this legal notice by way of post or speed post or courier to the specific address, but he is sending a legal notice by way of email, by way of WhatsApp, by way of Twitter, or by any other mode of social media or electronics mode. Then under these circumstances, what would be the position as far as the cause of action is arisen? Because these all electronic medias can be accessible from any corner of the world, from air, from ocean. Mr. B on a ship can access or can receive that notice. Then the cause of action is arisen on ocean or in air, in a flight. Then which court has to decide to take the cognizance? The special statute remains silent as far as the cause of action is arisen, or as far as for filing the suit of groundless threat is concerned. The special statutes say about infringement of any IP rights, that yes, there is an infringement, then one has to take the action being plaintiff where he is residing or carrying out business. Section 20, if we take the help of Section 20, then Section 20 itself has certain limitation as far as I have just said, that internet or this media, social media. If I am sending this, or if Mr. A is sending a legal notice by way of email, then that email can be accessible from any corner of the world. Then what about the cause of action to be taken against Mr. A by Mr. B, who is on the ship in some ocean? Special statute remains silent as far as institution of the suit for groundless threat is concerned. That is why I am asking you, those who are IP practitioners, that what about the cause of action for filing the suit to be considered, or from where Mr. B, in our example, should file a suit? Friends, there are number of judgments, but there are number of judgments in respect of advertisement, in respect of selling goods, in respect of circulation, but those circulation, advertisement or goods being sold are there physically. That is why those courts have jurisdiction. That is correct, that is understood, and that is legal as well, because it says cause of action is arisen. I am circulating an advertisement in Ahmedabad, then naturally the court situated in Ahmedabad has jurisdiction. I am circulating or I am selling my goods in Ahmedabad or in Mumbai, then naturally Mumbai or Ahmedabad court has jurisdiction. But I am telling that, or I am talking about that no goods, no circulation, nothing, no advertisement is there. Only I am sending a legal notice by way of email, by way of WhatsApp. Then what about the cause of action? Because that can be accessible from any corner of the world. Friends, kindly answer me. I hope you enjoy this video, you like this video. If you like this video, please don't forget to subscribe my channel. Thanks a lot.